Someone in Washington just tried to argue their authority outweighs a unanimous Supreme Court ruling. And they did it under oath on camera in front of millions. And that's exactly where Dan Goldman stepped in, not to defend a person, but to defend the Constitution itself. What unfolded wasn't just a tense back and forth. It was the kind of confrontation that exposes what happens when power collides with the limits placed on it. Because when a high-ranking official refuses to follow a 9-0 decision from the nation's highest court, the question becomes simple. If the rules don't apply to the powerful, who do they apply to at all?
And they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today, that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
so
sir, and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
no.
is investigators and law enforcement
officers. That is you making that determination.
Against him. If you don't trust
the court has considered all that. The judge has considered all that, Madam Secretary. And if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What steps have you taken?
If your continued advocacy for him were to...
I'm not advocating for him. I'm advocating for a court order, Madam Secretary. The court order says that you must take steps to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this
be
court order.
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
Gentleman's
and you
time
should
has
fight too for
expired.
due process.
The gentleman's time is.
This hearing didn't start as a showdown. It began like any ordinary oversight moment, with Goldman calmly preparing to walk through a case most people had never heard of. But buried inside that case was a fault line, one that would turn into a constitutional earthquake before the exchange was over. The case involved a man named Kilmar Abrego Garcia, deported years ago, sent back to El Salvador, and labeled by the government as someone connected to a violent organization. But the details of the man weren't the point. What mattered was this. The Supreme Court said unanimously that he was denied due process. 9 justices across ideological lines agreed the government violated the law. In a country that can't even agree on what day it is, a 9-0 ruling is a major red flag that something went seriously wrong. Goldman understood that. The moment the hearing opened, he didn't jump into political rhetoric or headline-ready accusations. He started with something far more basic, something every American learns in school, something the secretary sitting across from him couldn't afford to get wrong. He asked who, in the United States, has the authority to interpret the law. Not enforce it, not write it, interpret it. The executive branch or the judiciary? It should have been the easiest question of the hearing. And yet the hesitation in her voice told the entire story. She circled around the question, giving explanations no one asked for. Goldman didn't budge. He asked again. And eventually she admitted it, the judiciary interprets the law. And that's when the real trouble began. Because once she confirmed that the courts, not her agency, define what the law means, Goldman wasted no time bringing out the ruling she'd spent the morning trying to gloss over. The Supreme Court said this man was denied due process. Not maybe. Not partially. Not subject to debate. They said it unanimously. And according to the Constitution she swore to uphold, that should have been the end of the story. But instead of acknowledging that reality, she repeated the same line over and over, that in her view, the man had been treated appropriately. Her view. Her agency's view. As if that somehow outranked the highest court in the nation, Goldman wasn't having it. He reminded her that opinions are not rulings, and agency labels are not legal findings. He referenced Judge Wilkinson, a conservative circuit judge, someone no one could accuse of political bias in favor of the opposing party. Wilkinson wrote something chilling. The government asserts this man is dangerous. Maybe that's true, but maybe it isn't. It doesn't matter. He is still entitled to due process. Wilkinson warned that if the government is so confident in its accusations, it should have no problem proving them in the proper setting. In a lawful proceeding, not through administrative shortcuts. This wasn't a minor technicality. It was a case where the government skipped a step so essential that the Supreme Court agreed unanimously it violated the law. And yet the secretary kept leaning on the same message, that law enforcement said the man was dangerous, and therefore the agency's actions were justified. But that's exactly the problem Goldman was highlighting. In a system built on checks and balances, the government cannot deny rights based solely on its own claims. It must prove them. That's when Goldman pressed the question that set off the most intense moment of the entire exchange. Would she commit, right there under oath, to following the Supreme Court's order and giving this man the due process he was denied? Would she commit to obeying the constitutional process that governs every other case? His question wasn't about defending the individual. It was about defending the rule of law. But instead of answering, she dodged. She pivoted. She slipped into talking points. She refused to say the words every public official should be able to say without hesitation. Yes, I will follow the ruling. Goldman asked again. She dodged again. The tension was so thick at this point the entire room felt like it was holding its breath. Because her refusal wasn't just evasive, it was alarming. A top government official refusing to commit to enforcing a Supreme Court ruling is the kind of thing that makes constitutional scholars sit up straight. Ignoring Congress is one thing. Ignoring a unanimous Supreme Court is a crisis of its own. And then came the familiar pivot, the tactic used for decades whenever a government official wants to avoid accountability. She reframed Goldman's insistence on due process as him defending a dangerous individual. She tried to flip his constitutional argument into an emotional accusation, suggesting he cared more about someone labeled as dangerous than about the safety of his constituents. It was a classic move, the kind designed to generate headlines rather than substance. But Goldman wasn't playing the rhetorical game. He reminded her that due process applies regardless of accusations. The government doesn't get to decide someone's fate by simply repeating labels. It has to prosecute those claims in the proper venue. That's when he asked the question she absolutely could not answer. What steps has she taken to comply with the Supreme Court order? Not how she feels about the order. Not what she thinks of the man. Not what her agency believes. What steps has she taken to follow the ruling that the court explicitly said requires action? The ruling didn't say the government should consider action. It didn't suggest optional compliance. It said the government must facilitate due process, an active requirement. And she couldn't name a single step. She tried to shift the conversation again, insisting the man was already in his home country. She implied that the ruling didn't require anything more. She tried to cast Goldman as someone fighting for a dangerous figure instead of someone fighting for constitutional order. But the more she dodged, the clearer the truth became. The administration hadn't followed the ruling. They weren't planning to. And they were prepared to argue that their judgment held more weight than the unanimous interpretation of the Supreme Court. That moment wasn't about partisan politics. It wasn't about the man at the center of the case. It was about whether the executive branch believes it is above judicial review. In the United States, the system is designed to prevent exactly that kind of imbalance. The judicial branch is the final interpreter of the law, not because judges are perfect, but because the Constitution requires a neutral referee, someone outside the political arena, to decide what the law actually means. If the executive branch can decide on its own which rulings to follow and which to ignore, then the entire structure collapses. Goldman didn't let that point fade. He kept returning to the heart of the issue. If the government truly believes its evidence is strong, then the appropriate forum is a lawful proceeding. Not a claim made in a hearing. Not a press release. Not a label repeated by officials. A legal process where evidence is presented, challenged, and judged according to the rules written into the Constitution. And in that room for those few minutes, everyone watching understood what was really at stake. It wasn't just about one man or one case. It was about whether the branches of government still recognize the limits placed on them, whether powerful officials still respect the authority of the courts, whether due process still means something in practice, not just in theory. Because once a government official declares that their opinion carries more weight than a Supreme Court ruling, every person in the country is one accusation away from losing their rights without a hearing. That's why Goldman pushed so hard. He wasn't defending a stranger. He was defending the structure that protects every American, even the ones the government claims to already know are guilty. This hearing became a warning sign, one that deserves more attention than it's getting. It exposed how easily the rule of law can start to slip. Not through dramatic gestures, but through small refusals, subtle deflections, and officials who insist that their judgment is final. When Goldman pressed again and again, he wasn't grandstanding. He was doing the one thing every elected official should do, making sure no one in power forgets that they are not above the Constitution. And if you want breakdowns that go past the headlines, past the noise, and straight into the deeper stakes hidden inside moments like this, make sure you like the video, subscribe, and turn on notifications. Because this wasn't just a heated hearing. It was a glimpse into what happens when power forgets the limits that keep it in check, and why it's so important that someone is willing to confront it.